5 seconds to go. Start. It requires institutional care or administration of therapeutic care for medical insanity may not still be sufficient insulate the person from consequences of a criminal act and punishment if she is not legally insane. The assessment shall be to elicit such information as the law qualifies the general exception for proof of culpability under Section 84 of IPC. Is the accused mentally unsound? Is the mental unsoundness such that she is not capable of knowing the nature of act or the act is wrong or contrary to law? These questions are directly related to testing the requirement of law. Is she capable of understanding the nature of proceedings in court and stand trial? This shall be necessary to ensure that he has sufficient ability to consult with his counsel, instruct him for a fair trial and defense. Every accused is bound to know the nature of proceedings against him her. What was the mental condition of the accused when the crime took place? Is it likely that the accused is malingering mental illness? The answers will point out to fixing the criminal responsibility to the acts attributed to him her. Post trial care may issue questions like what is prognosis for cure for the mental illness? Will she be dangerous not to be let at large? In many a foreign jurisdiction, the questions may vary depending on the nature of proof of insanity and its intensity that is relevant under law to appraise criminal responsibility for the act. Could there have been an irresistible impulse to commit the act charged with? Was the mental condition to swear that she had no capacity to control his her behavior? Was she under any form of delusion to inflict the criminal assault to fend off falsely perceived personal harm or injury? The evaluation process generally includes broadly three major components or sources of data: an interview with the accused, forensic assessment instruments, and third party information, including but by no means limited to collateral reports, witness statements, victim statements, police reports, and records of various sorts, that is, mental health, treatment, school, medical, crime scene, etc. Along with these sources, the role of delusions in evaluations of criminal responsibility, as the nature and quality of the accused delusionality is often central in determining the extent of impairment in mental state at the time of the offense, especially in contested cases that may have a bearing on limiting responsibility if not completely exonerating him from the offense charged with. The role of the expert is not to present legal conclusions or formal psychopathological diagnosis. Rather, the role of examiner as expert is to import state of the art science knowledge about the existence of various psychopathological conditions and their relationship to various behavioral, perceptual, cognitive, and judgmental capacities into the legal moral decisional process. The case of the prosecution is that the appellant attacked the deceased at a store in which he was working, which belonged to the brother of his grandfather, who did not have any issue. There was no motive, and the overt act attributed is that he assaulted the deceased with an iron locking plate without any provocation and premeditation. The occurrence took place on 14th May 2004 at 6 am. It was seen by PW2. He took the material object and came out of the shop and went to the bus stand. Thereafter, he came back to the shop and left it there. He once again walked to the bus stand and was sitting on a chair. He neither moved away from the said place nor made any attempt to leave. A treatment was indeed given to him at the GMC Hospital Bhiwani in the state of Haryana prior to the occurrence. He was taken as an inpatient for a period from 17th November 2003 till 26th November 2003. He was suffering from anxiety neurosis with reactive depression and had symptoms of acid peptic disease and mild hypertension. The treatment given to him was akin to one meant for schizophrenia. Accordingly, he was prescribed the medicine. Before the Court of Sessions, an application under Section 329 of CRPC was filed on behalf of the appellant. Even while considering the application for bail, the court noticed the inability of the appellant to understand the ongoing proceedings. Two doctors were examined as AWs 1 and 2 for the fact that he was indeed suffering from schizophrenia. AW2 was examined to show that he was taking the treatment earlier at GMC Hospital at Bhiwani. AW1 is the doctor who examined him after the occurrence on the orders of the trial court. She had deposed that he was indeed suffering from chronic schizophrenia. She was further examined as DW1. She once again made a clear deposition in tune with the certificate issued by her earlier that he was suffering from schizophrenia and it must have been from the age of 14 or 15 years. Stop.